All rise. Board of Appeal in and for the 5th District of the State of Florida is now in session. Honorable Vincent G. Corby Jr., Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. Thank God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning and welcome to a brief session of the court. Today we only have one case on the docket. I'm joined today by Judge Palmer to my right and Judge Wallace to my left. The case we have today is it pronounced HEYLIN?
Yes, sir.
HEYLIN versus GULFSTREAM Property. It's a civil case, so you have 20 minutes per side, and the appellant may reserve. I have 5 minutes set on the clock. But if you'd like a different amount of rebuttal time, just let me know and I'll adjust the clock accordingly. Is counsel ready to proceed?
Yes, sir.
All right, yes, sir.
May it please the court. My name is Adam Richardson, and I represent Michael.
Adam Richardson.
Yes, sir.
Okay, yes.
I represent Michael HEYLIN, the defendant in the proceeding below, and I would like to reserve 5 minutes for rebuttal.
All right, sir.
We're here today asking the court to reverse the trial court's declaratory judgment in favor of GULFSTREAM Insurance. The trial court determined that the insurance company, GULFSTREAM, did not have a duty to defend or indemnify its insureds, the Muddards, for the...
I've seen a lot of these modern policies where they have a provision that, you know, the expected and intended language has been in these policies for as long as I can remember. But a lot of the modern policies have a separate clause that says no coverage for intentional torts, or, you know, sometimes they have a laundry list of the torts, battery, sexual battery, things like that. This policy is devoid of that language. Is that correct?
In this specific instance, yes. The exclusion is specifically for the, if I may bring it up, the intentional or expected or intended injury that's on record page 62, and it says bodily injury or property damage which is expected or intended by an insured.
But I mean, there's nothing in there that laundry lists different kinds of torts that are not covered, right?
Not that I saw, Your Honor. And of course, that would be unlike that 4th District case, I believe it's Valero, where there was such a laundry list. Some of the parts of the list said and insured, some of them didn't have any qualification. And yes, Your Honor, in that case, there wouldn't be any qualification, whether it is an insured, any insured, or just anyone else who committed the intentional act.
Now, the Adams case has drawn some criticism.
Some criticism, but I think, Your Honor, that that is just a reflection of the split of authority in the jurisdictions in this country. It has also been cited by approval with the federal court. I believe it's the 1st District, the 1st Circuit. But you're right, Your Honor, it has come down for some criticism, sometimes specifically. But, Your Honor, this court has not receded from that, and the Florida Supreme Court has not abrogated or overruled Premier v. Adams.
I didn't see any district courts of appeal in Florida that had expressed conflict with Adams. Is that your understanding, that
That is my understanding.
so far there's no express conflict with Adams?
Yes, Your Honor. I have not seen any case from Florida that expressly conflicts with it or that even impliedly conflicts with Premier versus Adams. It is, to my knowledge, still good law.
What do you think the sentence means that says this insurance applies separately to each insured?
Your Honor, I believe that it means what it says, that it creates separate insurable interests as to each insured, and that the court would have to interpret the language and apply the policy separately as to each insured person. Actually, the 4th District, in a case called Shrutima, held that the severability provision does that. It creates these separate insurable interests, and it went up to the Florida Supreme Court. And while the Florida Supreme Court ultimately discharged jurisdiction, it approved of the decision that the 4th District rendered, saying, of course, that these create these separate insurable interests. And of course, in Adams, this court held the same.
other than the example that we have in this case, can you give me a hypothetical example where the separately, applies separately to each insured language would be applicable?
Your Honor, there are other exclusions in the policy, and I'm sure that there are exclusions that would do the same thing, where it would exclude as to one person but not as to the other. But, Your Honor, I think for the most part it does apply to these negligent supervision claims that are premised on an intentional tort that otherwise would be excluded from coverage under the policy. Your Honor, the trial court and the opposing side had cited another case of this court. I'm not going to get the pronunciation correct. I believe it's Hrinko. And in that case, there was a joint obligations provision which does the exact opposite of what the severability provision in this case does. It creates one joint legally inseparable party, and if one insured commits an intentional tort against someone, then that intentional tort is imputed to the other insureds. For example, if there was such a provision in this case, to the parents, the mothers, and then there would be no coverage under the policy.
The appellee, they argued the joint obligations clause that was, I don't know that I could pronounce the name of the case as well, the HEYLIN case. I think that's going to be my best attempt here. They cited to the joint obligations clause in that case for support for their position in the motion for summary judgment. On appeal, are they once again continuing that argument with regard to the joint obligations clause, or have they now not argued that at this level?
Your Honor, they did in the motion for summary judgment state that they analogize the joint obligations clause in the case with the name I can't pronounce to the severability provision in this case. As we stated in the briefs, there was no explanation for why the two were supposed to be treated similarly, even though they're quite obviously intended to create different results.
Now, I think they've now said that that's irrelevant, the joint obligations
Yes,
clause is irrelevant to their argument.
Yes, Your Honor. In their brief, in one of the footnotes, they do say that it doesn't matter that there is a joint obligations provision in Hrinko and a severability provision in this case. But I think that that's a misreading of the case, because it's very clear that in Hrinko, there was, the court's holding turned on the presence of the joint obligations provision. It said that what this did was it created that joint inseparable legal entity. It cited to another case from out of state. It quoted it, saying that this is the effect of this provision. And if there hadn't been that provision, I'm sure that the court might have reached a different result. They might have said, well, we understand, we have this uninsured or any insured, and that might be ambiguous given these circumstances. But the fact is that that provision was in that insurance policy. The court relied on it in its holding, and it is relevant. And it's relevant to this case in the sense that, again, there is no similar provision in this case. There's a severability provision, which this court in Premier versus Adams held does the exact opposite. It creates separate insurable interests. I believe for that reason that Hrinko is clearly distinguishable, and that if this court were to follow Adams and reverse, there would be no conflict. In fact, in Hrinko, Judge Sawaya cited to Premier versus Adams in a footnote for a different proposition. Clearly, the court was aware of it. Judge Sawaya was aware of it. And in citing to it in a footnote but not discussing it, I think it's clear that he realized that it was so distinguishable that he didn't need to discuss it.
Could you touch on the preservation issue? We have no transcript from the motion for summary judgment. Your client chose not to respond to file a response to the motion for summary judgment. So how has this issue regarding the ambiguity been preserved at the trial court level?
Yes, Your Honor. First, I just want to observe that there is no requirement for a written response. Here, however,
Only if there's a local rule that says you have to do it, and there's none in this case, right?
Your Honor, that is a good question. I did not think of it, candidly, and I'm going to assume there isn't unless...
Well, it hadn't been raised as a part of the record in this case, that there was some local rule that required a response, right?
No, it's not in the record in this case, Your Honor. So in this case, we have a notice of filing of case law that we filed in the trial court that provided the court not only with a citation, but a copy of Premier versus Adams, which is the controlling case, and the leading case in the country from Massachusetts, Worcester, which the court in Adams heavily relied on. It's true there's no transcript of the summary judgment hearing, Judge Wallace, but there was that notice of case filing, and then in the motion for rehearing, we made the same argument. We said there's a severability provision, it creates an ambiguity, Florida case law says that, and for that reason, there is coverage here. In their response to that motion for rehearing, they said that we had made that argument. They said that this was briefed and argued, the court made a determination, but that the court should not reconsider its ruling. Effectively, they have conceded that this was preserved, that we raised this timely. The court heard our argument and just ruled against us. But that establishes that it was preserved.
Well, it was their motion for summary judgment, right?
Yes, Your Honor, it was their
A
motion.
deck action.
Yes, sir.
So they had the burden to establish that there was no coverage under the policy.
Yes, Your Honor.
And you all did not admit that, right?
Admit
You
that.
didn't admit there was no coverage.
Absolutely not, Your Honor. We denied those allegations in our answer and affirmative defenses. I think that's
So
pretty...
it was purely a question of law that was presented to the trial court.
Absolutely, Your Honor.
Necessary to have a transcript of a hearing when the argument relates to issues of law?
No, Your Honor, and that is another issue. So there is that conflict in Florida law on whether or not you do need to bring up the transcript of a summary judgment hearing to the district court in order to show preservation of error.
Conflict in the law on that?
I think that the cases can't be reconciled. I think that there is a conflict, certainly between the first district, which says that you do need to furnish the summary judgment hearing so that the district court can determine what arguments the parties made, and certainly the third and the fourth districts that have held that this is a legal issue. The hearing on a summary judgment motion consists of only the argument of counsel, that's not evidence, and that the appellate court is in just as good a position as the trial court to rule on these matters of law because they don't determine, like in an Applegate case, conflicted factual questions. There's no evidence, there's nothing precluding the court from considering the same material that was before the trial court and reaching a different conclusion. Your Honor, Judge Torpey, you talked about how Premier versus Adams has come into criticism after it was issued, but again, no court in this state has cited to or relied on it, but no court has receded from it, especially not this court. It remains good law. Now, there is, as I said before, a split of authority, but it is, I believe, incorrect to say that there's an overwhelming majority, there's a very small minority. This is really a split of authority. We cited to a case from California Supreme Court that discusses it in those terms, and if you look at the citations in the briefs, it's, I think, pretty clear that there's an equal or more or less equal amount of weight on either side. The other side asked this court to reconsider or recede from Premier versus Adams, but under the doctrine of stare decisis, it takes more than believing that the previous decision is just wrong, and in this case, it has not been so roundly condemned that it would justify departing from the doctrine of stare decisis and receding from the case. Here, it's just a long-running dispute between the courts, the jurisdictions, as to the interaction between an intentional acts exclusion on one hand and the severability provision on the other. There are two other points that I wanted to raise regarding Adams. In the opposing party's brief, they say that there's a distinction between that case and this case because in that case, the insurance policy said any insured in the intentional acts exclusion, whereas in this case it says an insured. And Your Honor, I don't believe that makes a difference. In Adams, this court cited, when it was discussing the line of cases that ultimately followed, two cases from other states where the language was an insured, just like this case. So even if the court maybe has not explicitly held that an insured and severability provision creates an ambiguity, it surely has impliedly recognized that.
Isn't and any synonyms in this context?
Yes, Your Honor, and most of the cases that discuss that recognize that they are both indefinite articles as opposed to the, which is a definite article. And for that reason, they don't distinguish between the two. In fact, two of the cases that GULFSTREAM relies on support that proposition, that there is no difference between any insured and an insured. That's Woodward from Vermont and Johnson versus Allstate from Maine. So even the cases GULFSTREAM cites support the proposition that there is no such distinction between the two words. And the other is, in this case, there is...
You're using your rebuttal time, that's okay. Go
Yes,
ahead.
Your Honor, I understand.
I'll alert you to that.
I appreciate the courtesy. There is on page 47 of the record something that says, under both sections 1 and 2, when the word "an" immediately precedes the word "insured," the words "an insured" together mean one or more insureds. And GULFSTREAM has argued that that removes any possible ambiguity, and I apologize if I'm misstating the other party's position, any ambiguity from the presence of the severability provision and the intentional acts exclusion. But the ambiguity is created by the presence of the severability provision. If this policy had only had the intentional acts exclusion and this one that I just quoted, then yes, it would be unambiguous. But the severability provision nonetheless creates an ambiguity. And I will reserve the rest of my time for rebuttal. Thank you.
You've got almost 4 minutes.
Good morning. I'm Hinda Klein here on behalf of GULFSTREAM. Our first argument and our primary argument is that the arguments that are raised in this appeal were not raised before the trial court. As a result, they have not been preserved for this court's review. I certainly agree with the court that there is no requirement in every summary judgment case that there be a transcript, nor is there a requirement that I am aware of in the law or by local rule that requires a written response.
How are the arguments presented at this level different from the arguments that were presented in the motion for rehearing and the filing of the Adams case prior to the motion for summary judgment?
Well, with respect to the rehearing, there's a single line in the motion for rehearing that the order granting the plaintiff's motion ignored the language of the plaintiff's policy, i.e. severability clause, which Florida appellate case law states in cases similar to the present one creates an ambiguity as to who is an insured, and any ambiguity should be construed in favor of the plaintiff as to the coverage, thus summary judgment was improvidently granted. There is no citation to any case law. The argument that it creates an ambiguity as to who is an insured is confusing and unspecific. It does not say that it creates an ambiguity with respect to the application of the intentional tort exclusion or the language in the policy.
Let me ask you this, Ms. Klein. The movement for summary judgment files a motion, schedules it for hearing.
Yes.
The opposing party does not appear at the hearing. The trial judge grants the motion, albeit it's an erroneous ruling. Is there a preservation issue there in that context?
I would say that there is. I'm not saying that this court should affirm it by default, because of course,
So
the court on a de novo
trial
review.
judge can grant summary judgment, which is inappropriate, an erroneous grant of summary judgment where the movant has the burden, and if the appellee has either not appeared at the hearing or not made an argument, they're precluded from addressing that error on appeal.
Yes, I believe that they would
Are
be.
you aware of any decision that says that?
No, all of the decisions that we cited in our brief involve situations where there was some shred of a record to support, that the appellee had made to support the arguments that they were raising on appeal. In this case, it does not appear consistent with the law in this state that in order to raise an issue on appeal, one must have preserved it before the trial court. If simply because it's a summary judgment, the appealing party did not have to preserve the record in any way, shape, or form.
I'm sorry, go ahead.
Does the record establish that the Adams case was presented to the trial court?
Yes, it establishes that it was filed.
That established that the issue's properly before the court.
Because merely because the Adams case was filed doesn't mean that the specific arguments that are raised in the initial brief were actually all brought to the attention of the trial court. As the court knows, the trial court's order on summary judgment, which I would submit could have cured it had it reflected that there was some consideration of the severability clause, but the court's order in this case doesn't address the severability clause.
Why isn't the Adams case controlling, putting the preservation issue aside, let's get to the substance?
It is controlling. It absolutely is controlling in this case. I can't argue in good faith that it's not.
Well, you tried to in your brief, right? You tried to make a distinction between any and an. You're abandoning that
I
distinction?
am abandoning that, yes.
So in order for you to prevail, we would have to go in bank and recede from Adams if we don't buy your preservation issue?
Yes. I think that this court sort of moved towards that in the, again, I can't pronounce it, the Hrinko case, but in a footnote, basically dodged the potential of having to go en banc by simply...
We never en banc anything, you know that.
I understand, Your Honor. I believe that there is a history of that. In any event, I think that in the Hrinko case, rather than address this issue head-on, and as the court knows, it's only 6 years ago, and well past, I think it was 14 years after the Premier case, the Adams case, where this issue was somewhat addressed, and I think it was Judge Sawaya who mentioned in a footnote, while Allstate urges us to go there, we've decided we don't have to because of the joint obligations clause. I would submit that that this court should go there, that this is a precedent that really, while nothing drastic has occurred since the precedent issued, certainly the courts have, the number of courts that we've cited have been strongly against this court's reasoning, finding that the intentional tort exclusion is a matter of public policy.
Apparently nothing drastic has occurred to the extent of the insurance companies thinking it was necessary to change their policies. I mean, that would be the easy fix, right?
That would be, yes.
But they haven't considered it of enough magnitude or significance to change the wording of their policy, right? Why should we look to change the case law?
Well, they also have not changed the policy language, which has been upheld time and again, that says an occurrence is defined as an accident. And that's something that none of these courts have addressed. It's outside the scope of the policy to begin with. I would submit that this court doesn't even have to address the exclusion if it finds that the policy simply doesn't cover an intentional tort, because it is not an accident. That is not dependent on and
Well, it doesn't cover
insured and...
intentional tort, but it does cover a cause of action in negligence, right?
Yes,
The
well...
cause of action that was pled here was not a cause of action for an intentional tort, it was a cause of action for negligence.
Right, but the courts throughout this state have routinely found that where the underlying act for which an insured is being sued is clearly an intentional tort, like in the bar fight cases, the Marr versus Greco cases, where there's a bar fight, an assault and battery between two patrons, and the bar owner is sued for negligent supervision. Those cases are excluded under the intentional tort exclusion, and also, more importantly, outside the scope of the policy. It's a matter of public policy throughout the country that we don't want to insure people for intentional torts or for causes of action that are couched in terms of negligence, but which are bottomed on intentional torts. And in this court's Frinko, again, I'm mispronouncing it, opinion, Judge Sawaya also reiterated that public policy. And it appears to me that this court's decision in the Adams case is frankly contrary to that public policy. It encourages creative pleading. And arguably encourages people to commit intentional torts, or at least doesn't dissuade them from committing intentional torts, because at the end of the day, the insurance company is going to be on the hook, which is precisely the reason why.
If the insurance company chooses to write their policy better, then they're not going to be on the hook, right?
Yes.
Some of
That
them
would-
have. I mean, you've got a lot of insurance clients. that
Yes, they have.
I've seen these provisions where they say, you know, everything notwithstanding in the foregoing, no coverage for, and, you know, they enumerate the torts, sexual battery, they enumerate intentional.
Yes, Valero was an example of that. But
What do you think this sentence means, this insurance applies separately to each insured?
I believe that it just requires the court to look at the claims against each insured and say whether, as to that particular insured, the policy provides that coverage without regard to whether it applies.
Doesn't help me much, Ms. Klein. What I want to know is if we struck that sentence out of there in its entirety, give me a scenario where our application of the language, the rest of the language of the policy might be different.
Well, if the court looks at the Sakura Supreme Insurance case, that's one of the cases we cited, the Court of Appeals out of Minnesota, they actually do go through that analysis. And this is how they
The
explain.
result would be the same in every hypothetical situation without that sentence, except for the one we're in right now, right?
I'm not sure I follow, Your Honor.
Well, I mean, you can't think of a hypothetical situation, aside from the instant case, where the application of that language would give rise to a different result.
Well, I know that, I believe that it has been applied in first-party cases where one party breaches the policy conditions, that the innocent co-insured cases, for example. And
One insured breaches and the other one doesn't.
the other one doesn't, and that's,
They impute the
that's,
breach, okay.
yeah.
All right.
But the way that the Sakura court has explained it, it says, when applying the criminal act exclusion of Patrick McCardle alone, as the severability clause requires, the plain and unambiguous exclusion of coverage for Larson's negligence claim because of the bodily injuries that are claimed are premised on resulted from the criminal acts of any insured, with the any insured being MCM, which is the intentional tortfeasor. The same result occurs when the policy is applied separately to Suzanne McCardle, who was sued for negligence. The act of applying the policy separately to each insured does not alter or create ambiguity in the substance or sweep of the exclusion. So what they say is, regardless of which insured you're talking about, if the claim results from the criminal or intentional or expected or intended act of an insured, it reads the same way. And really, that's the only sensical way, I think, to look at the severability clause, because to hold otherwise, and many of the courts that we have cited have said this, to hold otherwise basically eviscerates the intentional act exclusion, and I would submit it also would eviscerate the policy language which only provides coverage to anybody for something that is not expected or intended, only as to an accident, which this clearly was not. With respect to, let's see, I would also point out, and I think I might have already noted this for the court, that Judge Sawaya in the Harinko case did give credence to the still existing public policy that insurance should not cover an intentional tort because it either encourages intentional torts or fails to discourage them. And certainly in this case, that would be the precise result. I know it is very difficult, as Judge Torpy had noted, to get this court to reconsider its prior decisions en banc, but I really do submit that this issue is one that will crop up again and again, and it is a significant one given the overriding public policy. And in the event that this court finds that the arguments raised by the appellant were properly preserved, I would request that this court consider this issue en banc and recede from its prior opinion in Adams.
Given the prevalence of these types of clauses in homeowners insurance policies, there really would be no way for parents to obtain any protection with regard to the tortious conduct of their children.
Well, arguably, but I did want to point out, and really this is not an issue that was in the forefront in this DEC action, but for the most part, parents are not vicariously liable for their children's torts, nor are they ordinarily liable for negligent supervision unless it's a real child. In this case, this was a 17-year-old person. So, again, I don't see that as a countervailing policy decision because the tort law has already eviscerated any potential liability there. So, thank you for your consideration.
Thank you, counsel. All right, you got 3 minutes and 43 seconds.
Thank you, Your Honor. The first proposition I would like to address is that Harinko moves away from Adams. I don't believe that that's true. It, again, cites to Adams, and it doesn't say, I mean, there are such different cases that there was no reason for the court to discuss Adams in that case. And the presence of the severability provision here is that distinction.
You can make that argument in your response to her motion for en banc. I mean, this panel is bound by Adams, and we're going to follow Adams, and, you know, it'll be up to the full court to decide whether to receive from it, so.
Of course, Your Honor. I will then move on. As to preservation, there is no difference between the arguments that we make on appeal and what we made in the motion for rehearing. I do want to point out that the filing of Adams did bring that issue before the trial court.
You know, what disturbs me about this whole preservation line of authorities is there seems to be some competing legal tenets. There's a legal tenet in the context of motions for summary judgment that the movement carries the burden, and the opposing party has no burden whatsoever. But then there's a legal tenet of appellate jurisprudence that says that in order to argue an issue on appeal, you got to give the trial judge an opportunity to err. So you've got to make the argument to the trial judge so that the trial judge has the right argument, and we're an error-correcting court. So how do you reconcile those two competing legal tenets?
Well, I want to go back to a hypothetical that you asked Ms. Klein about. What the preservation situation would be if the appellant wholly failed to appear at the summary judgment hearing. There, it's clear that the appellant didn't make any argument, assuming, of course, that there was no written response or filing of any authority. So there would be no, it would be clear there that there would be no preservation.
Well, I don't, I asked her that question because I think it is preserved, but.
Well, I would defer to Your Honor.
I don't think that you have any burden to oppose a motion for summary judgment. The movement has the entire burden below, and if the trial judge makes the wrong ruling, I'm pretty sure there's cases out there where we've reversed the trial judge. But go ahead. You were getting to the heart of my question.
Well, here, this case, the facts, it's very clear that these arguments were made to the trial court, and the only possible obstacle is the lack of the hearing transcript. But this is so much different than a case where the standard of, it's a discretionary decision with a trial judge, where you would want to defer to the trial court, or it's a factual issue where you need to review the evidence. And I think you're right, Your Honor, that where it's a legal argument, the preservation concern is so much less than in those other situations. And you're right, Your Honor, that there is that burden of the moving party for summary judgment to demonstrate that they are entitled to summary judgment. And here on this record, and certainly some of the other hypotheticals I discussed, it's clear that the other party here, Gulfstream, did not at all satisfy their burden. And we can see that on the face of the record.
You're over time, and counsel didn't even use all her time. So
yes, Your Honor, I'm sorry, I apologize.
Thank you. For a well-argued case. Have a safe trip home.